come back to Florida. This happens fairly frequently. I'm not aware of any prosecutions ever to have resulted from these. Normally these cases get dropped. Mr. Meister has to go to work tomorrow. In Arkansas, I'm asking the court to ROR because it's unlikely the state is going to follow through with this. And according to the police report, the alleged victim in the case had intended to drop the restraining order, but did not. So I'll just ROR him, let him be on his way, and he can.
What do you mean he's going to work in Arkansas? Does he live in Arkansas?
That's where he lives, in Arkansas. Yes, Judge. This warrant is out of Arkansas.
The what? Oh, the injunction out of Arkansas.
Yes, sir.
It's out of Arkansas. So the alleged victim lives in Arkansas as well.
Yes, sir.
I didn't realize.
So again, this is a fairly common thing. We see it a couple of times a week. They come back off of a cruise and end up spending the night in Broward County Jail. I'm just no reason for us to take any more of his money or time, and ask the court to ROR him.
State's position.
Your Honor, I didn't know the facts of where they live or anything like that, but I had made a note based on what I read that I thought a $500 bond would be fair.
And Judge, I just point out to the court that there are no allegations of any issues having occurred during the cruise. Apparently everything is going well.
And do you have any
No, nothing we were able to find. That's just from the state of Florida, though.
I'm sorry. So what? You already answered. I didn't hear it. What is your position?
The state.
$500 bond?
Yes, Judge.
Judge, if I may, if the state's asking for $500 bond, if Mr. Meister doesn't have $500 to bond, he would go through a bondsman. He would have to pay them $100 to bond out, and they would post the surety.
I don't know.
The court would.
Somehow he got here from Arkansas to go on a cruise. So I mean, it's not like he's got a job. It's not like he's are you suggesting he's
right? I'm just suggesting, Judge, if he's unable to post a $500 bond, and he would go through a surety, he'd have to pay them $100. If the court wants to impose a bond on him, if you could just set it at $100 and let him self-bond.
Okay, in any event, the decision as to whether to prosecute this charge is going to have to be made in Arkansas, obviously, right?
No, sir. The violation occurred here in Florida, and this Broward County will determine whether or not to prosecute this violation of injunction. Now, Arkansas can do whatever they want based on these facts, but the allegation
injunction came out of Arkansas. Is that correct?
Yes, Judge.
So
that's correct.
Would not the Arkansas authorities have to make the decision as to whether or not to prosecute him for violating this injunction that came out of their court?
Judge, it's my understanding that both jurisdictions independently can prosecute for the same crime because they're separate sovereignties. Broward County would have to make the decision whether or not to prosecute him here, and Arkansas, based on these facts, could decide whether to prosecute him there.
Well, in reality, I would assume Broward County is not going to prosecute him for this charge. It's going to have to be a decision made in Arkansas. Anyways,
right.
I'll set bond the amount of $100. Okay.
Thank you, Judge.
Yes, he's not. Well, I'm going to set. Hold on 1 second. I'm going to set bonding amount. I want to set bonding amount of $100, but I'm ordering still that he's not to have any contact at all. So I don't know whether he plans on flying back or drive. Did you drive here or fly here?
We flew in. We're going to change flights, so From what I understand, my flight's supposed to be changed so we're not together.
Yes, okay, he's not to have any contact at all with her, directly or indirectly, by telephone, in writing, or in person. So I'll set bond at $100, but I'm directing because, again, the Arkansas authorities are going to make the decision, and this is a questionable violation here, to be honest with you. So I certainly would not inure to your advantage to continue to be with her after you're here in court, okay? So I would urge you that if you're going to go back to Arkansas, which apparently you are, not to go back with her. Yes, sir.
Just briefly, Judge.
don't get off.
Your Honor can order. Your Honor has the option to order no harmful contact. They can still contact each other. It doesn't seem that there was any indication of violence. The alleged victim stated that she intended on removing the injunction if they're planning on going back to Arkansas.
Right now, the injunction, I assume, says no contact at all. I don't know for sure. I haven't seen the injunction, but I'm just going to order no contact. Thank you.
Thank you, Judge.
All right, next case. Okay, I'll tell you what the next case is. The next case is John Leon Rodriguez.
Main jail, Judge.
Good morning, John.
Outside, sir.
He speaks English?
Yes, he does, Judge.
Okay. All right, sir, you're charged with domestic violence, battery, and I've read over the probable cause affidavit. I find there's probable cause. I'll set bond amount of $1,500.
Thank you, Judge.
No
Augustine
contact
Bernard?
at all. He's not to have any contact at all, directly or indirectly, with the alleged victim in this case.
Yes, Your Honor.
Next case is Augustine Bernard.
Good morning, Your Honor.
Morning. I read over this probable cause affidavit. I find there is probable cause in this particular case with respect to count 3 ROR, with respect to count 1 and count 2. I'll set bond amount of $2,500 with respect to each count. The total bond is $5,000.
Okay.
Well, ROR, I'm not requiring a bond on count 3.
Your Honor, may I just put on the record that the state was going to ask for an increased bond on Mr. Bernard in the amount of $15,000. He has at least 4 documented arrests for aggravated battery, and I was able to look them up, and they're all the same victim. So based on his history with her, the fact that he's had felony batteries with the same victim, the state's going to be asking for an increased bond amount of $15,000.
Well, what was the outcome? Those are convictions?
They were out of county, and I wasn't able to see the police reports or the reasons. For whatever reasons, they weren't pursued. I couldn't say if that's because, you know, the victim for whatever reason didn't cooperate, or maybe the case wasn't as great. I don't know the reason, but I do have documentation that he was arrested for aggravated batteries, and it was involving the same person.
Judge, we would just ask the court to keep the bond as set. All of these allegations in the past, none of them were ever proven.
Well,
all of the
I don't
cases
know
were
what the
dropped.
outcome of those cases were. She only has arrest but no outcome. No
My
decision.
client is advising me they were all dropped, so I'll
Okay, what I'm going
share
to do
that
in
with
this
the court.
particular case, just to protect everybody's best interest in this particular case, I will leave the amount of the bond the same. I'll indicate when I say no harmful contact at all with the victim that he's not going to be allowed to reside with the victim in the same residence at all during the pendency of this case. And I'm also going to require him to be on pretrial release with the electronic monitor level 2. I will not increase $2,500 on count 1, $2,500 on count 2, ROR on count 3. He's not to have any contact at all, directly or indirectly, with the victim, which includes he's not allowed to reside with the victim in the same residence. And I'll order that he's going to be on pretrial release with the electronic monitor level 2. Thank you.
Thank you, Judge.
Okay, Devon Dominguez. Okay, you speak English, sir?
Yes, sir.
Okay, you're charged with domestic violence by battery. I've read over the probable cause in this case. I find there is probable cause. I'm going to set bond in view of the circumstances here in the amount of $4,000. It's not to have any contact at all, directly or indirectly, with the alleged victim in this case. And again, if you all from the prosecutor's office have more information about, history, it's don't be afraid to pipe in.
Yes, Judge.
Okay, Cordell Taylor.
North Broward?
Yes.
Cordell Taylor, he's charged with battery in a dating relationship. On that particular charge, based upon the probable cause affidavit here, I'll set bond in the amount of $3,000. He's not to have any contact at all, directly or indirectly, with the alleged victim in this case. He's also being held no bond on a violation of probation. Thank you. Hiram Neal.
Judge, Mr. Neal is present at the main jail. We're requesting a photo order for him, please.
Granted. Okay, I've read over the probable cause affidavit in this particular case. He's charged with a domestic violence, a battery. I find there is probable cause. I'll set bond in the amount of $4,000 on that offense. He also has three separate warrants outstanding for him, and one is for a burglary, a second's for a burglary, and the other one's for a grand theft, each of which has no bond set. So he's being held no bond on these three different warrants. Thank you.
Thank you, Judge.
And Judge, no contact, please.
He's not to have any contact at all, directly or indirectly, with the alleged victim in this case. Clovis Thomas.
Thank you, Judge.
Okay, Mr. Thomas is charged with possession of marijuana less than 20 grams. I find there's probable cause for that. The bond will be set in the amount of $100. And with respect to that's count 3. With respect to count 1 and count 2, where he's charged with in count 2 with domestic violence, battery, and count 1 aggravated assault, I find there is probable cause. I'll set bond in the amount of $1,500 on each count. Count 1, $1,500. Count 2, $1,500. Count 3, $100.
Judge, Mr. Thomas asked the court to consider putting him on release on recognizance.
Own a property for 12 years.
State, what's the state having this gentleman?
No known history that I was able to find in our system, but I was going to recommend a bond of $7,500.
You're recommending bond of $7,500?
Yes.
You folks make me look good here today. Okay. So, based upon the facts of this particular case, I've read them over here. I'm going to have to keep the bond as it is. Thank you.
Thank you, Judge.
No contact at all, directly or indirectly, with the alleged victims in this case. Okay, Ozzy Gandhi.
Me too.
Ozzy's charged with domestic battery by strangulation. I read over the probable cause in this particular case. I find there's probable cause. Ma'am, you are?
I'm the victim.
You're the alleged victim in this
Yes.
particular case, and your name for the record is
Lisa Marie Halen.
Halen? Okay. And did you want to say something?
I do. He's never been in trouble. It was a fight that got out of hand, and I do not wish to pursue it on my end. He just started a new job. He served our country for 12 years. He suffers from PTSD, and I would like to see him get help for that. He's very combative, and we were just very, very angry, and words were said, and
More than just words were said, ma'am.
I know. I just don't want to see anything happen to his job, because he just came here from Houston. He fell on hard times in Houston, came here. I opened up my home to him to help him. He found a great job, and it was just something that happened.
Or did you call the police?
I did.
Okay.
I was very angry. I just wanted him to stop screaming at me, and it just got out of control.
Are you denying the facts that are set forth in the probable cause affidavit as to what happened here?
He didn't strangle me. He was trying to hold me. And I got very angry about that. He grabbed me by my neck and was trying to hold me. And I don't know what would have happened had he not done that. I probably,
According to what the officer said here, is that
he picked up
called you a bitch. Let me finish. He called you a bitch. He called you a bitch, and that you came into the laundry room holding, and that he came into the laundry room holding a vase from the living room in his right hand and started to choke her with his left hand. And you stated that he pinned you against the washer and that you were unable to breathe, but did not lose consciousness. Is that correct?
No. He had his, I wasn't able to breathe.
I don't want to get into the facts of the case. I just want to find out whether you agree or disagree with what.
I disagree, no.
Well, why did you call the police then?
Because I wanted him to leave.
Okay.
And he left before they got there.
All right, this lady said that you were in the military, sir. What branch?
Army, sir. 12 years.
Okay. What's the nature of your discharge?
Honorable discharge.
Okay. And why did you, out of curiosity, if you had 12 years in, how come you left after 12 rather than staying 20 to a pension?
I got tired of being deployed to Iraq and Afghanistan. I just got tired of it.
So where do you live, sir?
I'm living with her right now.
That's your permanent address with her?
Yes, sir.
So you don't live in Houston anymore?
No, sir. I'm transferring from Houston to here because I have a great job.
What's your job?
And I'm living with her. Yes, sir.
No, what's your job?
Before I work on every kind of lift there is for Dade County, Broward County. I work on every forklift they have.
Your mechanic?
Yes, sir. I'm a diesel technician.
Judge, in light of the alleged victim's testimony and Mr. Gandy's service, he'll likely resolve this case through Veterans Court anyway. If it's not dropped outright, I would ask the court to consider release on recognizance and allow no harmful contact. You might consider, Judge, pretrial release with a mental health evaluation as a condition of his release.
What's the state evidence, Joe?
Just a 1986 grand theft, and that was all that we were able to find.
What was the
Florida.
disposition of that case? He was in the military. I assume that he wasn't convicted of that.
Right, it didn't notate a conviction in it. It just said that he had an arrest for it back in '86, and with the system that we have this morning, it won't say whether it was dropped or there was a withholding.
Okay, the best I can do for this particular case, and you say you were deployed in Iraq and Afghanistan?
Yes, sir. 2 tours. Yes, sir.
Okay, the best I can do in this particular case is I'll set bond in the amount of $500. I'll order these going to be on pre-trial release with the electronic monitor level 2. He's not going to be allowed to reside with this lady. That's absolutely. He's not going to be allowed to reside with her. No ifs, ands, and buts about it. Okay, thank you.
Judge, may
Do
I
not
ask
have
the
any
court?
contact at all, directly or indirectly, by telephone, in writing, or in person with her? Yes.
May I ask the court to reconsider the electronic monitor? I don't think he's a flight risk. He came here to work, to take a job. He has no history of disobeying court orders.
Did you just ask me before for pre-trial release?
Right. I was asking the court to consider instead standard level pretrial release with the condition that he get a mental health eval while he's out.
Okay, I have no problem with him getting a mental health evaluation, but I will stand by my position to be on pre-trial release with the electronic monitor. I would say, however, that when he appears in front of the assigned judge, that if in fact there's no problem between now and his appearance in front of the assigned judge, that you remove the monitor. Okay, that would be my recommendation. Thank you.
Okay, there you go.
Thank you, sir.
Good luck.
Okay, next case in this
Morgan?
turtle-like process is Niger Morgan.
Main jail.
Okay, Mr. Morgan is charged with aggravated assault with a deadly weapon in the context of a domestic violence and touching or striking with domestic violence battery. I find there's probable cause. I'll set bond on count one, $1,000. Count two, $1,000 in order that he not have any contact at all, directly or indirectly, with the alleged victim in this case. That leads me to Yasser Garcia Victoria.
Will require a Spanish interpreter, Judge.
And what's his country of origin? Que su país, senor?
Cuba, Judge.
Do you swear to translate from Spanish to English and English to Spanish the following colloquy is about to unfold?
I will, Your Honor. Luis Angela Lopez, LOPEZ, Spanish interpreter for the courthouse.
Okay. He's charged with aggravated battery on a pregnant woman. And I've read over the probable cause affidavit in this particular case. I'll order that bond be set in this particular case in view of the circumstances in the amount of $3,500.
I'm sorry, Your Honor. $3,500?
Yes.
Thank you, Your Honor.
$3,500. And
Yes,
not
sir.
to have any contact at all, directly or indirectly, with the alleged victim in this case.
Señor García Victoria, a usted lo acusan de agresión corporal agravada a una persona que estaba embarazada debido a que el señor juez se encuentra motivo fundado después de haber leído el affidavit de motivo fundado y los hechos de este caso en particular. Le ordena que se le imponga una fianza de $3,500. Usted no puede tener contacto directo o indirecto con la supuesta víctima.
Okay.
That leads me to
Tienes
Justin
preguntas?
Aguilar.
Perdón.
No? Okay. Okay, good luck. Main jail, Judge.
Does he speak English?
Yes, sir.
You do? Okay. All right. So, Mr. Aguilar, he's charged with aggravated battery on a pregnant woman. Count one. Count two is false imprisonment of a child under 13 years of age. And count three is robbery, strong-arm robbery. I find there's probable cause in this particular case. I'll set bond with respect to count one to $2,000. On count one, $500. And count three, $1,500.
Judge, just respectfully, as to count one, I would argue that there's no probable cause. The PC affidavit states that the alleged victim was pregnant. However, there are no facts alleging that Mr. Aguilar knew or should have known that she was pregnant at the time.
Since they're involved in a romantic relationship and the victim is 36 weeks pregnant, which is unless she was, 36 weeks translates into 9 months. So, I mean, I don't want to go any further on that topic than that issue, but,
I understand.
pregnant, and they were involved, it says right here, they were romantically involved with one another, and it says that,
That's true, Judge.
the father of the child. Again, this is not beyond the exclusion of every reasonable doubt, but only probable cause.
I understand. But still, it does not state that Mr. Aguilar knew or should have known. I understand that she was 36 weeks pregnant. However,
Did I say 36 months? I meant to say 36 weeks, not 36 months.
36 months would be a little... So I would just stand by my argument. And further, as to count two, I don't think there's any indication of age as to the false imprisonment allegation.
But I think the false imprisonment is talking about the child that she's carrying, right? I didn't see any
Unborn
reference to
child.
another child here. I assume that's the...
It says adult or child under 13 years.
probable cause determination sheet here, it says count 2, false imprisonment, child under 13 years of age. I don't see any reference to any other child in this probable cause affidavit unless I missed it here. I thought that the child they're referring to was the one in the stomach.
I'm looking at the actual probable cause affidavit where it says charges, and on the second one, it says third degree felony, and then under that it says adult or child under 13 years of age. So for the
Oh, okay.
yeah, I read it in the alternative. So it could be an adult, or it could have been a child under the age of 13.
Okay, he's reading the same thing I am, which is you're reading the probable cause determination sheet?
You're
Yes,
reading
sir.
the booking sheet?
I'm reading the booking report,
Oh,
yeah.
you're looking at the booking sheet? The arrest report, you mean?
Yes, sir.
I'm reading the actual
Says
probable
adult
cause.
or child under 13. So your position is that is the victim of the in count 1 is the same as the victim in count 2.
I'm not saying,
That's the way I'm reading it, as it was charged in the alternative. It was an adult or it was a child, and in this case, it's an adult.
Well, either way, it seems to me it passes muster, so I'll let that stand then. Whether they're talking about the unborn child in the mother's womb, or they're talking about the mother herself as being the victim of false imprisonment. You're right, it is a little unclear here as to who they're talking about. So, all right, then what I'm going to do then with respect to count 2, then I'll give this, the state 48 hours to amend that, the probable cause affidavit with respect to count 2 to identify who the victim in that case is. But with respect to count 1 and count 3, it's respectively $2,000 bond, $1,500 bond.
And Your Honor is giving 24 hours.
No, I said 48.
Okay, 48 hours to add the specific name of the victim.
Yeah, I'm a little. When I read this the first time, to be honest with you, I thought it was the unborn child they were talking about, but I didn't. And even if you look at the book, at the probable cause affidavit itself, as opposed to the probable cause determination sheet, it doesn't really specify who the victim is of that.
Well, okay, and if I could just respond, just maybe to save some time and not have to perfect. It says that the victim and the suspect are in a romantic relationship. The victim is 36 weeks
Right.
pregnant. The victim attempted to leave the apartment, however, the defendant did not allow her to leave, so that would be the false imprisonment, and they're still referring to the same victim who's in the relationship, who's 36 weeks pregnant. And then the officers charged it under the statute, which is in the alternative, adult or child.
Your response to that?
I just stand by my original argument, Judge.
Then I will recede from my requirement that the state have to perfect count 2, so I'll leave bond at count 2 as I originally said at $500. And defendants not to have any contact at all, directly or indirectly, with the alleged victim in this case.
So it's count 1, 2,000, count 2, 900, count 3, 1,500.
Yes. Yes. Get the pretrial service order, or they do?
Thank you.
Okay, Amelia Castro,
Medical reset, Judge.
okay,
Straight up, sir.
we'll set that for tomorrow. All right. Jessica Leak,
Main jails. I'm sorry, North Broward, Judge.
okay, I find there's probable cause in this particular case. State have a history on this lady?
One moment.
We are trying to, we don't have that one. We do?
No known priors, Judge.
What?
No known priors.
Okay, she wants to resolve this case today in view of the facts that are alleged in the probable cause affidavit. I'll accept a plea of no contest, 4 days in Broward County Jail with credit for time served. What? Did you hear me, ma'am?
Yes?
Sorry, Judge?
Okay, what I'm offering you, if you want to resolve the case today, is that I would offer you a plea of no contest if you want to accept the plea of 4 days in Broward County Jail with credit for time served. You've been in apparently 1 day, I assume? This is your second day in custody?
Yes.
Okay, so that's the offer if you want to get it. You would have credit against the 4 days of 2 days sentence, okay?
Okay.
You want to accept that?
Okay.
Okay?
Yes.
I'll accept that plea. Thank you. If the state has nothing on her, it'll be a withhold. Okay, Janelle Nicholas?
Judge, I'm sorry.
Yes.
You offered her 4 days. Is that correct?
Offered her 4 days with credit for 2 days time served.
Right. So if the court is sentencing her to any time at all, then a withhold is inappropriate. It would have a withhold can only be withhold court costs, and you can take judicial notice of time already served, but I don't think the court can sentence her to time served and give her a withhold. I think that's a illegal sentence.
I agree with you, so but I'm going to stand by my offer of 4 days because of the circumstances of this probable cause affidavit. So
Yes, sir.
So then she'll have to be adjudicated then. Thank
Sir.
you.
Turn around.
Thank you, Judge.
Okay.
Is that me?
All right. I'm on Janelle Nicholas. Is that Janelle?
Main jail?
Okay.
Yes, sir.
All right. She's charged. There's an outstanding Capias for her for 500 with a bond set in the amount of $500.
Judge, do we have a court date for Miss Nicholas?
No. Let's see. This is for driving with a suspended driver's license. Is this her first? It says first offense. Do you have any priors on her?
One moment, Judge.
Zebedee, are you okay there with waiting with me here? I don't know which case you're on here, but
I'm fine.
okay.
I'm enjoying this. Bring back memories.
Yeah.
No known priors, but it looks like she has another DWLS pending. Here in Broward in front of Judge Backman.
Want to Judge Backman?
Yeah.
Not Paul Backman, his wife then,
I'm sorry?
right?
Yeah.
Well, the only problem with making an offer to her, if she has another unrelated DWLS, and then she resolves this one, that's 2 down and 1 to go for it to be a felony.
And I was just looking for
We're just having that conversation, Judge. She's fighting the other one.
Okay, well, she can get out of jail. She can post a $500 bond if she doesn't want to resolve this, and I would urge her to think seriously about admitting to this if she wants to.
Judge, the state's just gonna ask that she has to post the bond for the Capias and return to the judge that this is in front of.
That's what I just said, $500.
Is that like 10% of the?
She's going to bond out, Judge. Thank you.
Okay, thank you. Are we saying the same thing?
I guess so, maybe. I thought she was gonna maybe take an offer and I was
No,
just.
no, I told her I suggested she not take the
Oh,
offer.
okay.
Okay.
Yes, we are saying the same thing.
Okay, so Blanca Puerta,
North Broward?
North Broward?
okay, she's charged with DUI and DUI U-Ball. And I find there's probable cause in this particular case. The bond on count 1 is $500. Bond on count, which is a DUI. Bond on the DUI UBAL is $1,000. Total bond is $1,500.
Judge, I would ask if you would please consider pretrial release in this matter.
I'm talking about Blanca Puerta. Is that what you're talking about? What's the state's position on that? Oh, the bond's being posted? I didn't hear that. Okay, thank you. Nicole Boyking.
North Broward?
Okay. Nicole's charged with grand theft, $500 or more but less than $1,000, and fraud, attempted use of an ID of another person. I find it's probable cause. The total bond is $1,000 each count. Total bond is $2,000. With respect to Angel De Jesus,
North Broward?
North Broward?
Okay, in this particular case, there's a co-defendant, a male later on in the pack here, but with respect to her, I find that there is probable cause. I'm going to set bond on count 1, the amount of $1,500, and on count 2, $1,000. Total bond is $2,500. With respect to Dana Holinko,
Angel Judge.
Dana's charged in count 1 with grand theft. Oh, actually, these are Capiases that are outstanding. There's 2 different Capiases. Each Capias has 2 different counts. Count 1 and count 2 are contained in one Capias. The bond is $1,000 each count. And count 3 and count 4 are in another Capias. Count 3 is a grand theft. Count 4 is fraud, uttering a false instrument. Again, the bond is $1,000 each count. The bottom line is it's $4,000 bond she has to post to get out of jail. Thank you.
Thank you, Judge.
Kelly Davila.
North Broward,
North
Judge.
Broward, the medical reset.
Medical reset. Okay, that'll be reset until tomorrow. Audra Kelly.
Main jail.
Okay. Audra has a driving while license is suspended, third or subsequent offense. And I just noted here when I was looking, she had five prior driving while license suspended. And she also has an expired motor vehicle registration charge and driving with a vehicle that's unsafe or defective. I find there's probable cause in this particular case.
Judge?
Yes?
I was just going to advise the court, it appears there's a witness on her behalf.
Yes.
As a police court, Your Honor.
Mr. Wright, I know him. He's a former county court judge here. I know Mr. Wright, Zebedee Wright. How you doing, Zebedee?
Pretty good, Judge Spicer. I came in on her behalf because I know her. She's a former wife of my stepson.
Former wife of your stepson?
Yes.
Is that your current wife's son?
Yes.
Your current wife's son?
Yes.
Okay. She's a former wife of him?
Of him, yeah.
Not
But
yours.
I have a kind of close relationship with her because I raised their 2 sons that live with me right now. And she has 4 daughters. And I wanted to impose upon the court to allow her to be released in my custody. And I will assure all her appearances before the court. And in the meantime, I try to help her clean up her driving record. Because I can understand probably why she got in that situation with all those children, low-paying job, no money to take care of those things. So I would assure the court that she'll be at all court appearances, and I want to clean up her record in the meantime.
Okay, well, the bond...
Well, I know she has no money to get out, and she has 4 daughters at home.
Okay, ma'am, do you work?
Yes,
What do you do for a living?
embroidery.
Embroidery?
Yes,
And you work full-time?
yes.
Okay. And who do you reside with?
Deputy,
It's not
right?
a tough question, it's just a question, who do you live with?
Right now, I'm living with my boyfriend.
With your boyfriend, you don't have custody of your children?
Yes, we staying together.
I just asked you who you reside with, you just said your boyfriend. Is your boyfriend
Yes,
you
we
and
staying
your
together.
children?
Yes,
You have 4 children at home with you.
yes, at home with me, yes.
Can I keep your mouth closed?
Okay, what's the state position on this lady? To be honest with you, the bond here was set at $750. When I saw she had 5 priors, I was thinking about increasing it. What's your position?
All of the priors were the same charge. They're all misdemeanors. This time it is a felony. I think 750.
Trying to get to work.
What?
I said, trying to get to work. You know, you're trying to take care of 4 children and get a
Correct.
ticket, and you don't have any money to pay those things, so you still take a chance. So that's why I say I try to clean up a record for her.
I don't see any DUIs or any drug charges that would make her a danger to the road.
Now, she isn't gonna be on the road, they impound that regular truck she was driving, and they can keep it.
I think that it is a fair bond considering the charges. I mean, I think $750 is reasonable. I don't know that.
You're not in position to post that bond for?
No, I live on my Social Security and retirement now. How many years I've been retired?
I'd say
I don't
maybe
have the
about
money, that's
8.
why I'm here. You can't trust me to assure that she be in court?
Well, that's a very loaded question here that I can't trust you to bring her.
You know me well.
Okay, well, the best I can do under these circumstances is I would release her on pretrial release without the monitor. She'll be on pretrial release without the monitor. She'll have a curfew of 7 p.m.
Fair West.
And 7 p.m. at night till 7 p.m.
She
in the morning.
she worked from what time?
2 to 11.
2 to 11.
Oh, 2 to 11
Yeah.
p.m. Ask
Yeah.
her. Verify for me. I think it's 2 to 11.
What time do you work, ma'am?
From 2:30 to 11, but I have to get my kids at 2 o'clock. I have nobody to get them.
You have to what?
She picks up her children at 2, Judge.
I pick up my kids at 2. I drop them off and I go straight to
You're not
work
going to
at
be able to pick
2:30.
up anybody. You're not going to be driving the vehicle.
On the bus. I'll be able to do it on the bus.
No, the question is about this 7 p.m. curfew. And you say you work till 11 o'clock, so that's what you're trying to clear up. Don't worry about the daytime.
What days?
No,
Okay, we can't make this case a career, ma'am. What days do you work?
Monday through Friday.
Monday through Friday, okay?
Yes.
And so,
Midnight to 7 a.m., Your Honor, and then on Saturday and Sunday, 7 to 7.
yes, I'll go along with that.
That's good, John.
Okay, but I must advise you, ma'am, that if you're behind the wheel again, and you're driving a vehicle and you don't have a valid license, then I would urge whatever judge has this case that they hold you no bond, okay? Because this is now going to be charged against you as a felony because you've allegedly done this 5 prior times.
Dang.
Thank you.
And Judge, we would just ask the court, just advise the court that pretrial is closed tomorrow, so she'll have to report before, normally we would ask her to report before noon on Tuesday.
Okay, yes, Your Honor. Tomorrow, the office is closed. She'll have to report first thing Tuesday morning, and also she needs to vote. You guys need to give pretrial her address, the person she resides with, and her contact information, because she refused pretrial interview last night.
Oh, she did?
Yes. She said she'll prefer to bond. Oh, she got the money. I said she have her money to bond.
Oh, yeah. Listen, Zebedee, I mean, this is getting to be ridiculous here, okay?
Yeah, I don't want to take up
she
any more of
has-
your time.
She told me she didn't have the money to bond out of jail. And she told the person yesterday she didn't want to be interviewed by pretrial release, and she's going to bond out of jail.
All right.
I didn't know what it was, so I said,
Okay, listen, we can't have everybody talk here. Could you ask your client there, is she planning on bonding out of jail? Because if she
One
bonds
moment,
out of
Judge.
jail, then she won't have to be on pretrial
Yeah,
release.
don't have to be bothered.
But I thought you told me she didn't have the money to do that.
I think she was looking for me. I don't have that. How much it cost to get her out? What is that? $100 plus collateral with a bondsman.
Be 150. 150.
Okay, I have to move on, so
Yes, I'm telling you, I'm telling you, John.
I'll just leave the bond at $750 then, if she's gonna be able to bond out. She already had an opportunity to be with
indicating that she
pretrial
would-
release, she refused to.
no, he asked me that and I didn't know what it was. The man asked me that this morning, brother. He asked me that this morning and I didn't know what it was.
Didn't know what pretrial was?
Yes, I
Okay,
don't
now
know.
you want to do it?
Yes.
Okay. Judge, she's advising me she didn't understand what pretrial was. It wasn't explained to her. Now that she's had it explained to her, she would like to do it if the court is so inclined.
Okay, but what happens between now and Tuesday? She doesn't get out until she goes to pretrial release, is that correct?
No, she's tonight, and she'll have to report to our office first thing Tuesday morning.
Okay, what's first thing morning? What time?
The office opens up at 8 o'clock.
Y'all cross the street? Okay.
So at 8 a.m. on
Right
Tuesday.
around
I'll make sure she be
at
there
8
for that.
a.m. on Tuesday morning, she's supposed to be at pretrial release office. If she's not there, then I would direct you to present to me a Capias for her arrest, okay?
Thank you, Judge.
Thank you, Your Honor. What? Everybody have a good day. That's it.
Kenya Basilio.
Main jail, Judge.
Ms. Basilio, you're charged with count 1, petty theft. The bond is set in the amount of $25, and count 2 alleges probation violation, no bond. So she's being held no bond, plus there's a new charge of petty theft. Bond will be set at $25. Thank you.
Robert Gregory.
All right, there you go. Good luck to you, man.
Gregory Robert.
Lene Baker.
Paul Ryan
Paul
facility.
Ryan Facility.
Okay, she's charged in count 1 with touching or striking battery, and count 2 violation of probation, no bond. So she's going to be held no bond on the count 2 violation of probation with respect to the battery in this particular case. Based upon the facts, I'll set bond in the amount of $2,500.
No contact?
She's not to have any contact at all, directly or indirectly, with the alleged victim in this particular case.
Can you please release me?
No, ma'am, you're being held no bond based upon a prior.
So what I gotta do?
warrant
How long
issued.
I gotta wait? How long I
To
gotta
appear in
wait?
front of the judge that was set. Do we have a hearing date on that?
Just for the probation, which is on the 20th at 8:45.
On January 20th. Thank you.
Oh my God.
All right, next case I have is Mary Baker.
North Broward, Your Honor. She's going to be a medical reset, please.
Okay, we'll reset that till tomorrow. Christopher Haynes.
North Broward.
North Broward, Your Honor. Good morning.
Morning. There's an outstanding Capias for your arrest that was issued. It's a misdemeanor Capias. The judge that issued that indicated no bond. So that was Judge McHugh. She handles domestic violence issues, I believe. So you have to be held no bond. You're scheduled to be in front of her. Is there a date?
No, Judge, it's to be set.
To be set. Okay, thank you.
Thank you.
Jose Grant. Conti?
Yes, sir.
Okay, Mr. Grant, you're
Morning.
charged with violation of probation. There's a misdemeanor warrant that was issued for you, no bond, by Judge Gonzalez Levine. So he'll have to be held no bond. That's with respect to the charge of a simple battery. Thank you. His hearing is set on January 25th in front of the judge. With respect to Christopher Davis,
Yes, sir.
President, the main judge, may I address the court as a friend of the court, please?
you're my friend.
Well, for the purposes of this hearing, I would
Okay.
ask to be considered your friend, Judge.
Okay.
Okay, so this is a municipal ordinance charge from the city of Fort Lauderdale. I'm scanning the courtroom there. It does not appear that the prosecutor from the city of Fort Lauderdale is present, nor is the public defender from the city of Fort Lauderdale present. I would argue, Your Honor, that the state attorney does not have any standing in this case, nor do I for that matter, which is why I'm asking to address the court as amicus curiae. I would ask the court under those circumstances to consider dismissing this case for lack of prosecution or releasing Mr. Davis and all other municipal ordinance cases for the same reason. Release them on their own recognizance.
Date?
It was filed by the city. He failed to appear for his court date. The judge issued a bond. I don't know that dismissal is the appropriate solution.
Well, as I said, Judge, this court, if this court acts in this case in any way other than the way that I suggest or urge the court to consider, you're basically acting as prosecutor, defense attorney, and judge at the same time. I don't think that that's a legal position or even a position that the court would want to be in.
I don't see
to
how
act
this
as
case
all-
is any different from any other case where a judge issues orders that a Capias be issued. He was taken into custody.
Fact is, Judge, there's no one in that courtroom right now to prosecute the case. There's no one in that courtroom to defend this man, and you're going to have to go alone, and that puts you in a position of you're exposing the court is exposing himself to liability in this case for acting extrajudicially in this case.
Okay.
Your Honor, I disagree. We're not here for his prosecution. We're here for you to inform him that he failed to appear in court and he therefore has a bond amount assessed to him by a judge who's handling the case. We're not here to prosecute it or even make a PC determination.
Okay, bond is set in the amount of $500. Thank you.
Just advising the court. Thank you, Judge. Off you go. You got a bond. Roberts?
Down the middle.
Come on up. Down the middle, please. Out the door. Thank you.
Gregory
Thank
Roberts.
you. Down the middle, out the door.
Yes, sir.
Okay, Mr. Roberts is charged with DUI, alcohol, count 1, DUI with property, with damage to property or person of another, count 2, and count 3, DUI with damage to a property or person of another. This is a second alleged DUI. I will find that there is probable cause in this particular case. Bond will be set at $1,000 on count 1, $1,000 on count 2, $1,000 on count 3. Thank
Your
you.
Honor?
Yes?
Mr. Roberts, in July of 2015, was arrested for burglary of a dwelling, a second-degree felony. He's currently in front of Judge Singal. He did post bond on that case, and I'm just letting the court know that he was out on a bond when he picked this up. And if Your Honor wishes, you could revoke bond in his other case. I'm not asking to. I'm just informing the court.
That'll have to, he's out on pretrial release on that case or out on bond?
He's out on a bond on his other case, and if the court wishes, you can revoke bond on that case.
Or, Judge, in the alternative, you can leave it to the division judge to make the determination.
I will do that. Thank you.
Thank you, Judge. Off you go. Bond out. Get ready to go back in. William Alvarez?
William Alvarez, he's charged with 2 different...
Spanish, please, Judge.
No. This is William Alvarez?
Spanish interpreter present, señor. ¿Usted es William Álvarez?
Sí, señora.
Yes, ma'am.
What is your country of origin?
¿Cuál es su país de origen?
Mexico.
México.
Okay, Mr. Alvarez has 2 separate outstanding capias for his arrest, and the bond is set on each one in the amount of $100.
Señor, tienen 2 órdenes de captura separadamente en contra suya y el monto de fianza que han impuesto es de $100 para cada una.
I would note for the record that each capias charges him with no lodging on city-owned property.
Quiero para el acta informarle que a usted...
I'm sorry, one capias
Momento,
charges
señor.
him with no lodging on city-owned property. The other capias charges him with carrying an open container in public.
Se corrige el señor juez que una acusación es de estar, de que no había alojamiento, usted no debía alojarse en un lugar público de la ciudad, y la otra acusación era de llevar consigo un envase al descubierto y abierto.
¿Tienes preguntas? Yo no tengo trabajo.
I don't have any work.
What do you have in this, gentleman?
One moment, Judge.
Está preguntando el señor juez a la señora fiscal qué antecedentes tiene en su nombre. Un momento.
Just municipal ordinances for carrying open beverages in public.
La señora fiscal dice que solo tiene antecedentes de quebrantación de las leyes de una ciudad, de una municipalidad, de tener latas o envases abiertos o destapados.
Okay, the bond is $100 each count.
La fianza que le imponen es $100 por cada una de las acusaciones.
Thank you. Judge, this is
I
Ian
have
Burns.
to add, in that last case, it's pretty ridiculous to hold this gentleman for $100 on each count when it costs us $100 each day to hold somebody in custody.
Judge, you can dismiss the case. You can legally do that. Judge Bailey did it 2 weeks ago. Dismissed every single municipal ordinance case that came before him.
Okay, what I'm going to do in this particular case, I will stand by what I said on the prior case involving a municipal ordinance. But on this particular case, with respect to Mr.
Alvarez?
Mr. Alvarez, I'll dismiss the case.
Thank you, Judge.
Especially, again, since it costs us $100 every day to hold somebody in custody.
It's $117, Judge.
Okay, thank you. Ian Burns. Mr. Burns
Present at
is
the main.
charged in count 1 with possession of marijuana, synthetic marijuana, less than 3 grams. 2 counts of each of those he's charged. And drug paraphernalia. I find there's probable cause. The total bond is amount of $100.
Judge, any chance of resolving Mr. Burns'
State have an
charges?
offer on Mr. Burns?
Mr. Burns is currently on probation in front of Judge Gottlieb, and I believe that there may be a warrant coming through, so this would be the basis for the court violation, not going to be criminal.
He's on probation. I think it wouldn't make any sense to resolve this.
Oh,
case.
I would actually advise him not to as well, Judge.
Okay,
Thank you.
All right, Justo Lassus.
Spanish, Judge?
And what country is he from? ¿Qué es su país?
Puerto Rico.
Okay. You swear to translate from Spanish to English and English to Spanish upon colloquy is about to unfold?
I will, Your Honor. Lucy Angela Lopez, LOPEC, Spanish interpreter for the courthouse.
Okay, he's charged in count 1 with DUI with alcohol or drugs, first offense.
Señor, lo acusan, la primera acusación que tienen en contra suya es de estar conduciendo bajo los efectos de bebidas alcohólicas o drogas, y es el primer delito que le imponen.
Count 2 is charged with DUI, UBAL, U-ball.
Yes, Your Honor.
Count 3 is charged with operating without a valid driver's license, and count 4, careless driving.
La segunda acusación que tienen es de estar conduciendo bajo los efectos con un nivel en la sangre. El juez no especificó. La tercera acusación es de estar conduciendo con una licencia, perdón, sin una licencia válida, y la cuarta de estar conduciendo descuidadamente.
Okay, I find there's probable cause. The bond will be set on count 1, $500, count 2, $1,000.
Encuentro motivo fundado para detenerlo, dice el señor juez, y le impone una fianza de $500 para la primera acusación y $1,000 para la segunda acusación.
Thank you.
Hey, with respect
Bernardo?
Perdón, señor.
Lennon Aguilera.
Aguero. Yes, sir.
Speak English?
Yes.
Okay.
Yes, sir.
Yes.
He has 2 driving capiases outstanding, traffic capiases, 2 separate ones. The bond is set at $500 each one. Total $1,000. They're both driving while license is suspended.
Yes, Judge. Okay.
Renato Ramos Chales.
Spanish, please, Judge.
Yes, Your Honor.
¿Qué es su país, señor?
Señor, ¿cuál es su país de origen?
Guatemala. I know they all understand me. Okay, Guatemala.
¿Cuál, Your Honor? We say, ¿cuál es su país?
Wow, okay.
Yes, Your Honor.
Said it, okay.
Yes, Your Honor.
All right, so he has also an outstanding traffic infraction here. The bond has been set at $500.
Señor, el caso que tienen en contra suya es de estar operando sin una licencia válida, y la fianza que le han impuesto es de $500.
And according to the Capias here, the bond is to be set in the division.
Pardon me, Your Honor, may the interpreter correct the record?
The bond is $500.
Yes, Your Honor. Señor, lo que tienen en contra suya es una orden de captura por un caso de tránsito, de estar operando sin una licencia válida, y es de $500 la fianza que le imponen.
Thank you, Judge. Okay.
Next case is Stephen Syriacs.
Jail.
He's charged with petty theft. The bond is set at $25. Do you have any priors for him?
Yes, Judge. She has a 2014 resisting without violence, battery on a law enforcement officer, 08 battery, 07 resisting without violence and giving a false name, 06 loitering and prowling and carrying a concealed weapon, and a number of juvenile priors.
Any prior petty thefts?
Prior juvenile grand thefts.
Bond is $25.
Any chance of resolving this, Judge? It appears that Walgreens recovered everything.
Okay, this would be number 1 or possibly number 2 with respect to the elevating this to a felony.
Judge, apparently his juvenile priors would have
Too
been
old?
9 years old at this point.
Okay, well,
So,
okay, but then
I don't-
in any event, this would be number 1 if he wants to do this.
Let me explain it to him, Judge.
Does he have any? Is he on probation now?
He knows, Judge.
What'd you say?
He knows about the 3-strike rule, Judge.
You don't have him on probation now, right?
It does not appear that he's on probation.
Does he want to resolve this today?
Yes.
Okay,
Yes.
you understand that this would be one of 3 strikes against you, 2 more, and then the 3rd one would be charged as a felony. You understand that?
Yes, sir. Yes, sir.
Knowing that, you still want to accept a plea of an adjudication, time served?
Yes, sir.
Okay, I'll accept that. Thank you.
Good luck.
I'll impose
going home.
court costs as well.
Thank you, Judge.
Thank you. Next case I have is Wendy Pierre Louise.
North Broward?
North Broward, Your Honor. Medical reset, please.
Okay, thank you. We'll set that for tomorrow. How about Alvaro Mendoza Gutierrez?
Main jail, Spanish, Judge?
Spanish interpreter, Your Honor.
Okay, this particular case, the defendant is charged with domestic violence, battery.
Señor, en este caso en particular lo acusan de violencia intrafamiliar, agresión corporal.
I find there's probable cause. I'll set bond in this case in view of the facts of this case at $1,500.
He revisado el affidavit de motivo fundado, encuentro motivo fundado para detenerlo, impongo una fianza de $1,500.
No contact at all with the alleged victim in this case, directly or indirectly, in person, in writing, or by telephone.
Señor, no debe tener, le prohíben tener contacto o comunicación con la supuesta víctima, ya sea en persona, directa o indirectamente, o por teléfono.
¿Tienes preguntas?
¿Perdón?
¿Tienes preguntas?
No.
No. Thank you, Judge. Okay. Evan?
Very good.
Okay, Evan Flynn. Mr. Flynn is charged with domestic violence by battery. I've read over the probable cause in this case. In view of the facts that are set forth therein, bond will be set in the amount of $4,000. Defendant's not to have any contact at all, directly or indirectly, with the alleged victim in this case.
4,000. Yes, 4,000. Good luck, sir.
Okay, Earl Lipscomb.
Sit right over there.
Earl Lipscomb is charged in count 1 with trespass. Bond was set in the amount of $25. And count 2 and count 3 are separate capiases. Count 2 is for, I believe, urinating in public. And count 3 is for trespass. The total bond, I find, is probable cause with respect to count 1 for the $25. So the total bond that was set here is $2,125.
Judge, any chance of resolving these today? Counts 1 and 3?
Well, now, is there a 3-strike rule on trespass or not?
Not that I'm aware of, Judge.
Okay, then, because, which the state's offer? What do you have on him, or both?
2005 possession of cocaine, and 2013 they're just municipal ordinance violations for trespass, and logical sleeping in a public area, urinating in a, oh, that's this case.
He also has 2007 possession of drug paraphernalia and a possession of narcotics paraphernalia in 07.
Okay, you guys have an offer?
Y acá escribe tu nombre y ya.
Adjudication time served.
For second trespass, okay, okay, I'll offer him adjudication time served if he wants to accept this.
And don't go back
Yes,
to
sir.
Gulfstream.
And obviously, he's not allowed to go back to Gulfstream Park. If you go back there again, and they take you into custody, then you're not gonna get a sweet deal like you did today here. Do you understand that?
Yes, sir.
You have the wherewithal to stay away from Gulfstream Park?
Yes, I'm.
Okay, I'll accept a plea of guilty, adjudication, and time served. Thank you.
And Judge, would the court dismiss, would the court dismiss count 2 in light of the plea and counts 1 and 3?
No, thank you.
Okay.
Okay, Raphael Fossey?
Bonded.
Bonded?
He bonded, Judge. Dixon?
Logery, Dixon? What?
Main jail?
Yes, good question. Finders probable cause with respect to the DUI, yes. And count 1 as well, careless driving. Okay, with respect to Logery, Dixon, he's charged with battery in count 1 and resisting lawsuit without violence in count 2. I find there's probable cause. ROR on count 2, bond on count 1 is $1,000.
Your Honor, on this, I'd like to just put on the record that he has 2008 felony battery, 2009 battery, 2009 assault, 2010 battery.
Oh.
2015, he picked up another DV battery. The victim in this case, I believe, is his girlfriend's mother, and currently he has another pending battery from 2015 in front of Judge McHugh, where the victim in this case, her daughter. So I wrote down that I'd recommend a bond of $7,500. No contact with the mother and her daughter also.
Okay, in view of what the state's telling me, which is obviously adds a different perspective to this, places this charge in a different context, I'm going to increase the bond to $5,000, and order's going to have to be released on pretrial release with the electronic monitor level 2. $5,000 bond, yes.
Thank you, Judge.
Thank you. Okay, Jack Kelly.
Does Your Honor have a probable cause affidavit?
On who?
You do?
On who?
Jack Kelly.
Yes.
'Cause- yeah, we weren't provided one.
Well, what would you like me, you want to read it over here now, or what do you want to do?
Maybe we could put it on a recall.
Yeah, he has 102 counts.
Yeah.
102 counts. Count 1 and count 2 were sexual assault, and and the balance are all lewd and lascivious molestation. So, and these are all, this is as a result of an outstanding no bond Capias, I believe, or no bond warrant. All of these are no bond warrants, 102 counts. If you want me to put this on recall so you all can look this over, that's fine.
I don't know that there's a warrant,
It says,
so we might have to address it for PC determination.
okay, well, I'll withhold what my finding was until you all have a chance to read it then. There's no reason to withhold. I found that there was probable cause, but you all can read them over, okay?
Right, and he has no bond, I just wanted to look at it to see if this
Okay.
was something you were gonna address about giving.
All right, I'll put it on recall then. How about Hector Rodriguez?
Recall. Oh, you don't read. Judge, Mr. Rodriguez is president at the main jail. Arnold Blowstein is his attorney. I sent an email to him this morning to let him know that Mr. Rodriguez is in custody.
Is this Mr. Rodriguez?
Yes, this is.
So then you're not going to represent him?
No, Judge.
Okay, Mr. Rodriguez is charged with grand theft of an auto, and to be honest with you, in this particular case, I didn't find there was probable cause. So This is a co-defendant to the lady that I found. He was a co-defendant with this lady that I handled her case earlier. And this is a charge of grand theft of a motor vehicle. And the only evidence I found in here with respect to this defendant is that in his right rear pocket, in the right rear pocket of his shorts were the vehicle keys. But that's different, that could be possession of stolen property, but he's charged here with grand theft of the motor vehicle. According to the victim in this particular case, the person who went into his residence and took the vehicle keys was the co-defendant, De Jesus. So,
Right.
By the way, is anybody listening to me?
He was. We are, Judge.
Yes.
Okay.
He was intoxicated at the point.
Okay, don't say anything at all about the facts of the case, sir. Are you still on Ryan, or are you on this one? Okay, well, what I'll do is I found there's no probable cause, so I'll give the state 48 hours to perfect on this case. He's charged with 1 count of grand theft of an auto, and I have nothing in here about the grand theft that I see.
I would just argue that the one defendant made statements that the vehicle was stolen. He was in the vehicle. Was found for the principal neighborhood. He could be found. You have a lawyer theft auto just by his presence in the vehicle, knowing it was stolen.
I was not in the vehicle.
That's sir, don't say anything at all about the facts of the case. Last warning I'll give you. That sounds like a great stretch, but we're not here doing stretching today. So, like I say, I don't find probable cause with respect to this defendant, and I'll give the state 48 hours to perfect. But meanwhile, the bond is $1,000. Thank you. Okay, that leads us to Amnella Anderson. Amnella Anderson is charged with 1 count of DUI with alcohol or drugs, first offense, and all the other counts, and then counts 2 through 7 are DUI with damage to property or person of another, and count 8 charges him with driving while his license is suspended, third or subsequent offense, and count 9 and count 10 charge him with fleeing and resisting an officer without violence, respectively. I find there's probable cause on this case. The total bond is $7,350.
And just so the court's aware, he does currently have a pending DUI case in front of Judge Evans.
He has a 3rd pending, and this is a 4th one?
A 4th?
Well, it says, no, it says, I'm sorry. Did you say he has a DUI or driving with suspended license pending?
Right, and he is
No, which one?
a DUI.
Oh, okay, yeah, because this says it's his first DUI, but he has at least 3 or more prior driving with license suspended.
Correct.
Okay, in this particular case, then the bond will be $7,350 if he's able to bond out of jail. Can he speak English, by the way?
Yes, sir.
If he bonds out of jail, I'm going to order that he's going to have to be placed on pretrial release for the electronic monitor level 2. Thank you.
And Judge, did the court set a bond in count 9?
Count 9 was ROR.
Thank you, Judge. All right, you can bond out. Good luck. Woody Pittman.
Woody Pittman?
Main jail?
He's charged with violation of his probation.
Claudia? Next.
And that's going to be set down on January 20th of this year. And the judge on this particular case is Judge Destry. He's on probation now for a charge of possession of cocaine. No bond.
Okay.
Claudio Baltodano.
Main jail?
Do you speak English, sir?
Yeah, I speak English.
Okay, he's charged in count 1 with driving while license suspended, first offense. Count 2, driving with defective equipment. And count 3, a violation of probation. On a violation of probation, it's a no bond warrant. That's set in front of the judge on January 20th, 2016. And with respect to count 1, I'll set bond amount of $100. I find as probable cause. Count 2 will be ROR.
Thank you, Judge. Sorry?
Roland.
It means you're going to be held no bond until you see the judge on Wednesday. That's what I told you. Judge, I believe Mr. Etienne is entitled to bonds in counts 1 through 4.
He's what?
I believe that he's entitled to a bond in counts 1 through 4.
Entitled to a bond in counts 1 through 4.
Right, my docket shows no bond, but I believe that the court should give him some bond amount.
Okay, this is a no bond. Was this a defendant that was arrested in Indiana? I don't know. It says place of arrest, Indiana County or Indiana. But anyways, the charges here: aggravated assault on a law enforcement officer, aggravated fleeing, battery on a law enforcement officer, and resisting an officer with violence. And this was a no bond Capias that was issued. He was extradited from Indiana County. I think they mean Indiana. He was extradited from Indiana. And what is your reason for saying he's entitled to a bond?
Well, Judge, unless a court signed an order holding him no bond, these are bondable offenses. And so he is entitled to a bond as a matter of law.
Because this is the 9th, December 9th.
Did Judge Destry issue a no bond Capias for him?
No, it looks like the clerk issued a no bond Capias. He does have another pending case though, which is pending in front of Judge Destry with a court date of 2/29.
There's a pending case with Judge Destry.
Yes, in September of this year, he was arrested for fraud, forgery, and perjury, and he posted bond in that case on 9/2. He then, it appears, left the state, was picked up on, or no, he had other charges, and then I guess he was out of state and picked up there and brought here. So in this
Well,
case,
is this a Capias issue because he did not appear in court? I mean,
No.
Normally what happens is when you're in court.
on the original case, on the first case that he already has pending, there was no Capias. This has nothing to do with that. I was just letting you know that in Judge Destry, he did have another case.
Right.
This case, he was
Did he fail to show for an arraignment or?
there was a warrant to arrest signed by Judge McCarthy, and he was to be held no bond on that warrant, and then he was picked up out of state.
This case right here?
Yes.
Okay.
This crime occurred, and the officers then went to get a warrant signed, probably by the duty judge, and it was Judge McCarthy, so her warrant was no bond.
Okay. All right, so he'll have to be held no bond then.
Thank you, Judge.
Okay, Joseph Osbach. Okay, he's charged with burglary of an occupied conveyance and petty theft. This particular case, I didn't see enough there, to be honest with you, for an actual burglary charge as opposed to an attempted burglary in count 1. I'll hear the state on that.
Your Honor, if we could have 48 hours to have the officer either add more information or change the charge.
Okay, so I find no probable cause with respect to count 1. With respect to count 2, yeah, they're going to have to perfect the entire probable cause affidavit. So I'll give the state 48 hours to perfect the probable cause affidavit. You'll explain that to your client? Well, if he doesn't want to wait, of course, if he doesn't want to wait, the bond with respect to count 1 is $2,000 and the bond on count 2 is $100. Do you have priors on this, gentleman?
Nothing known in the state of Florida.
Where's this defendant from originally?
Ohio.
He lives in Ohio?
He's been here most of his life, Judge.
Okay, there we go. Thank you.
Judge, I'm not sure yet if he understands what his options are. Can I have one more moment?
Yeah, his options are he can post the bond right now. The bond on count 1 is $2,000. The bond on count 2 is $100. I'm finding, however, at this time there's no probable cause that I will give the prosecutor 48 hours from today to see if they can amend the probable cause affidavit.
Judge, would the court consider placing the bond in count 1 and 2 without prejudice and allow him to bond out if he can, and if not, bring him back in 2 days for the probable cause determination?
No, I'll have to leave it as I said. Thank you.
So,
Okay.
All right.
All right, so Radcliffe Barnett. Radcliffe in count 1 is charged with resisting an officer without violence. The bond is set at $100. With respect to counts 2, 3, and 4, count 2 is a felony Capias. It's outstanding for him. There was issued no bond. For possession of PCP. And count 3 and count 4 are misdemeanor Capiases. Actually, the felony Capias is that he failed to appear at his arraignment, so the judge ordered a no bond Capias. With respect to count 3 and count 4, they both emanate out of the same Capias, and that is a misdemeanor Capias for possession of paraphernalia, 2 counts. So the bottom line is, for the count 2, no bond. Count 1, resisting without violence, $100 bond. Count 3 and count 4, $250 each.
Judge, if I could just, with respect to count 1, I'd make a PC argument. There are no facts alleged that Mr. Barnett resisted or opposed without violence the officer in any way. If anything, what's alleged in the PC would be
Give a false name.
Yes, and that's not what he's charged with in this new case.
Well, what is your argument that giving somebody a false name is not resisting without violence?
Well, my argument is that the officer doesn't state in his PC argument that it obstructed his investigation in any way.
The officer made contact with the defendant Radcliffe Barnett, who stated his name was Steve Allen, and not can provide photographic identification. I mean, I don't have any cases that support either position, but my interpretation is if someone gives a false name to a police officer, that can be legitimately construed to be resisting the officer without violence. It obviously would not constitute a resisting with violence, but he's not charged with that. He's charged with the resisting without violence. So, State want to be heard on that?
I mean, at this point, he's trespassing, he's investigating a crime, and he's trying to figure out, and the guy could have refused to give any information, but instead, he did give information, it was false, and he obstructed the officer, so I would say that there is.
Okay, I'll have to respectfully deny your argument. Okay, thank you. That leads me to Torrance Smith. He's charged in count 1 with possession of burglary tools with intent to use, and count 2, loitering or prowling. I find there's probable cause on count 1. The bond is set at $1,000. Count 2, ROR. Okay. Robert Roberts. Mr. Roberts is charged in count 1 with driving while his license is suspended. First offense, bond is $100, fine probable cause. Count 2 is failure to wear a safety belt, ROR. Count 3 is a violation of probation. The bond was set at no bond on the violation of probation, and that was violation of drug offender probation. I don't have any indication who issued that bond. Do you?
I'm looking that up right now.
There just seems to be a little mix-up who's at the podium.
Little what?
A little mix-up who's at the podium.
I'm on Robert Roberts. Is that who you're on?
Yes, Judge.
Okay. Did he hear me?
Yes. Yes, sir.
Okay.
It looks like Judge Robinson.
Judge Michael Robinson?
Yes.
Okay. All right. Thank you.
Thank you, Judge.
Okay, Giovanni Torres, aggravated assault with a deadly weapon, domestic violence. I find there's probable cause in this particular case. I will set bond in the amount of $1,500. I'll order there to not be any contact at all, directly or indirectly, in person, in writing, or by telephone, or by computer with the alleged victim in this case.
Judge, I'd like to make a quick argument as to probable cause. There's no indication in the police report that the victim was in imminent fear of his safety at all.
So you're calling this mutual combat?
No, Judge, I'm just saying that I don't think it amounts to an aggravated assault.
Brother one, who is the defendant here, armed himself with a bat after they got into a verbal argument and started walking towards the victim in an aggressive manner. The mother walked between the two of them, and the victim walked out of the house and off of the property. State?
The defendant started walking towards him armed with a bat in an aggressive manner, causing the brother to obviously be in fear since he armed himself with a knife to protect him if he had to. If he wasn't in fear, I doubt he would have grabbed a knife. And it doesn't seem to be mutual combat because it was the defendant who initially grabbed a weapon and approached the victim.
That's what it says here, Brother one. The defendant armed himself with a bat and started walking towards the victim in an aggressive manner. Then the victim armed himself with a knife. And the mother had to step in between the two of them. No, I'll find this probable cause here. So the bond is as I said, is set at $1,500. Okay? Brandon Lacey.
Thank you, Judge.
Brandon Lacey.
That's a medical reset, Judge.
Thank you.
David Curry?
Yes, we'll set that for tomorrow. Next one is David Curry. He's charged
Main
with
jail.
petty theft from a transit agency, second offense. He's charged with committing theft, resisting recovery of property. He's charged with resisting an officer without violence. And there's a DOC hold, Department of Corrections hold, no bond. But I couldn't figure out for the life of me what is the petty theft from a transit agency. Does anybody know what, in the probable cause affidavit, what the petty theft is from a transit agency? I looked for that. I didn't see anything about a bus here. Maybe I overlooked it. Or a train, or a vehicle, or a camel, or a plane. I don't know. I didn't see anything. So with respect to count one, the recommended bond is ROR, and I'll go along with that, but I don't find probable cause for count one. If the state wants, I'll give them 48 hours to perfect on count one. Count two, I find there's probable cause, bond is set in the amount of $100. Count three, resisting officer without violence, it's recommended ROR, I'll go along with that. And count four is the no bond DOC hold. So, I think that's basically a parole violation.
Judge, I'm not sure exactly how this parole situation works, but obviously if Mr. Curry violated his parole with this case...
No, if you look at the last sentence here of the probable cause affidavit, it should be noted that a teletype check revealed a no bond active warrant out of Tallahassee for a violation of parole. Okay, thank you. Are you asking for 48 hours to perfect?
You ROR'd him on it?
Well, the recommendation is
I mean,
ROR,
it's no
yes.
bond. It's okay.
No, not asking for it. Okay. All right, Aguilar Castro.
Yes, sir.
Main jail judge, Mr. Castro is indicating that the charge in count two has been resolved. The Miami-Dade probation case from 2005 that he took care of last year, and I would ask the court to ask the state attorney to determine whether there is in fact an active warrant in this case.
Well, it's a misdemeanor warrant. Well, maybe it's not. I apologize. Let me just see here.
Your Honor, I think that Miami-Dade should probably just pick him up and resolve it down there. If in fact it was resolved, then they'll release him on that no bond hold.
We're showing he's still on probation.
You what?
His probation termination date ends on February 1st, 2018, so he's still on probation for Miami-Dade.
He's still on probation for Miami-Dade.
When he's done with his locals here, then we'll contact him.
Thank you for checking.
Okay, so count one is a grand theft. I find there's probable cause. The bond is $1,000. Count two is no bond. Louis Ben Naziri. You speak English, sir? Do you have your volume on there?
Yes, Judge, he does speak English.
Okay, he's charged with possession of a forged driver's license. Count one. Count two, driving while license suspended. First offense. Count three, possession of marijuana, 20 grams or less, synthetic. So I find there's probable cause. The total bond is $1,000 on count one. Count two and count three is ROR.
Good luck.
Brandon Torres. He's charged with grand theft. $300 to $1,000. I find there's probable cause. Even though the total amount here is $5.96 over the $300 threshold, $305.96. So I find his probable cause here, $1,000.
Thank you, Judge. Off you go. Good luck. Nathan Cole,
Cole? He's charged.
Farrell, Mark. You're on. This is Mr. Cole, Judge.
Okay, Mr. Cole's charged in count 1 with petty theft. Count 2, petty theft. Count 3, VO violation of probation. There's a felony warrant outstanding for him. No bond.
You're going to see the judge on Thursday.
The no bond, I think, comes out of West Palm Beach. And with respect to the probable cause on the 2 thefts, I find there's probable cause, petty theft. So the bond on count 1, petty theft, $250. Bond on count 2, petty theft, $250. The bond on the VOP is no bond.
Off you go.
Marvin Farrell.
Outside. Main jail, Judge.
Marvin's charged with burglary of an unoccupied conveyance in count 1, possession of burglary tools, count 2, grand theft, count 3, resisting officer without violence, count 4. I find there's probable cause. The total bond is $2,100.
Your Honor, I was going to ask the court for an increase of bond on Mr. Farrell. His priors include 2003 cocaine, 2006 false name, burglary, grand theft, burglary, 2008 grand theft, 2009 ag assault, aggravated fleeing and eluding ag assault, law enforcement officers, burglary, 2011 burglary, and 2011 cruelty to a child and resisting without violence. Currently, he has a fraud case pending in front of Judge Uson and another misdemeanor pending in front of Judge Gonzalez-Levine for resisting without violence. And now here he's back again with burglary, possession of burglary tools, grand theft, and resisting. So I was going to ask for a $15,000 bond.
$15,000 bond?
Yes.
Okay, what I'll do is, in view of his extensive record in the past and his present pending cases, with respect to count 2, I'll increase the bond from $1,000 to $5,000. With respect to count 2, $1,000 to $5,000, and count 4 will remain $100. So the total bond is now going to be $10,100.
Judge.
Oh,
Count 1.
Oh, count 1. Count 1 will be $2,500.
Will it record it?
And count 4 is $100, so it's a total of $12,600.
This is your bond.
Just briefly, I'd like to make an argument as to count 2. I don't believe there's probable cause to hold Mr. Farrell with possession of burglary tools. It's okay, I'm sorry, Judge. I don't believe that there's probable cause for count 2 in this case, Judge. The burglary tools alleged are his sweater.
What is it? Count 2.
Well, at first blush, I can understand where you're coming from, but what he basically was saying here, the officer is saying that he used the sweatshirt itself wasn't, as a disguise, wasn't used as a disguise to hide him. The sweatshirt was used apparently to wrap his hand around to enable him to break the glass, to get into the vehicle without injuring his hand. So,
I guess a counter argument would be anytime anybody has a sweatshirt, they're in possession of burglary tools.
Not necessarily, unless they use it to enable them. That was used to enable them to get into the vehicle without injuring himself. That's the argument I see. I don't know, State want to add anything?
I'm going to look up the jury instructions for possession of burglary tools real quick.
While you're doing that, I have to use the restroom.
Did you want to read the PC on that, Jack Kelly?
Promoter, it's 13.2 if you want to look at it yourself. I was just letting you know the jury instruction number.
Oh, yeah, I'm pulling it up.
No, just I'm a part-timer and cover the magistrate.
All right, so,
So I pulled up the jury instructions. You have to show that they intended to commit a burglary or trespass, which he did, and that they had in their possession a tool, machine, or implement that they intended to use or allowed to be used in the commission of the burglary. Honestly, I don't know what would satisfy the implement. There's no definition for it. I've never seen this before, charged as a burglary tool.
so the bottom line,
Bottom line, it was used to commit the burglary. Does the sweater wrapping his hand to like insulate it from the glass, does
Right.
that count as a burglary tool?
I think you have a good argument there, but again, we're only here to find out if it's probable cause, not be guilt beyond to the exclusion of every reasonable doubt. So I'll have to, but there is argument there. I think it's persuasive. Okay.
Kelly, Anthony?
So then I've already set the bond at. Thank you.
Anthony?
Vito Di Benedito.
Yeah, I couldn't find it in the help. Main jail, Judge.
He's charging count 1 with resisting an officer without violence, count 2 bribery of a public servant, and assault on an officer.
One moment.
And the support, I guess, for the for count 2, with respect to robbery of a public officer, is that while loading the defendant into the police vehicle, he offered the reporting officer and the deputy, Irizarry, $20 to let him go. So that's the bribery of a public officer, of a public servant. What's the state have on him?
He has a 2010 unlicensed contractor case, and he also has a pending case right now in front of Judge Brown, resisting without violence and disorderly conduct.
Okay, the bond here is $3,500 on count 2.
Judge,
count 1 and
wouldn't
count
the
3 is
offer
ROR,
constituting-
yes.
Judge, wouldn't the offer constitute an attempt rather than an actual bribery? Bringing it down a level?
Well, I don't know how the bribery statute reads, whether an offer...
That's what I was trying to look up.
I found it.
38.015 means corruptly give or offer, give, offer, or promise any public servant.
I think you answered the question. Thank you.
Thank you, Judge. Carry on. Sure, you can request ROR all day, Judge. He wants ROR.
Sir, I have no money, and I'm really in a tough spot right now. Could I get ROR on these charges? On all counts, please.
You say he has a pending charge now?
Yes.
Yeah, no.
That case.
No,
that case is gonna be resolved. Actually, that's Friday. I'm basically walking. I got that withhold certification.
Okay, I'll leave it as it is. Thank you.
Thank you.
Okay, Corey Williams. Corey's charged with violation of probation, felony. Capias was issued for him, no bond, and that's for a burglary. He's on probation for burglary of a structure and grand theft. It was Judge Bober. Okay, so he has to be held no bond.
Thank you. Good luck.
Carlos Alamar.
Good morning.
Morning, Carlos. You're charged with possession of alprazolam. You're charged with possession of marijuana less than 20 grams, synthetic. Oh, not either real marijuana or synthetic marijuana, and driving while license is suspended. How many prior driving while license suspended does he have? You know.
One moment.
I'm trying to figure this out. Are you twins?
We're not twins.
Huh?
Everyone always thinks so.
Oh.
I'm not seeing priors, but I don't have a. Oh, I see a prior GWLS in 2011. Another one in 2012. And that's all I'm seeing. I don't know what else he has out there.
Okay, so the bond here is $1,000. Thank you.
I'm sorry, Judge, what is the bond, please?
$1,000 on count 1 and ROR on count 2 and count 3.
Thank you, Judge.
And just so the court's aware, he has a pending possession of alprazolam in front of Judge Porter.
Okay, well, she may very well.
Judge, with regard to Mr. Ragland, we'll be requesting a mental health screen, please. If you note that on the probable cause determination, the sheriff's office will conduct the screen as requested.
Where is he?
He is at North Broward, Judge.
Mr. Ragland there? Oh, it's medical reset. You what? Okay, then I'll order he be subject to a medical assessment by the sheriff's office.
Your Honor, he's currently also being supervised for a pretrial release in 5 cases that's before Judge Ford. So we'll be requesting a ratification of his supervision.
You're asking me now to do that?
Medical reset?
Okay. Then I'll, in view of this offense here, I will revoke his pretrial release status.
Marie's keys in there? Yeah.
Do you fill in the date here, or do you need me to? He's being supervised on 5 cases?
Yes, Your Honor.
Which one is,
And will they all be held no bond?
The reset one?
Yes. So he has 5 prior driving licenses?
No, not prior drivers. It's a variation of cases, Your Honor.
Oh, I got you. Possession of cocaine, burglary, possession of cocaine, delivery of PVP, possession of PVP. And now we're here on a driving while license suspended 3rd or subsequent offense. Yes, I'll revoke his.
No, Your Honor.
Until he appears in front of Judge Ford, yes.
Thank you.
Okay. Anthony Pitticelli?
Main jail.
So we're not resetting.
Okay, Anthony's charged in count 1 with battery on an officer, count 2, possession of amphetamine, count 3, possession of heroin, count 4, possession of marijuana less than 20 grams, count 5, resisting an officer without violence, count 6, resisting an officer with violence, count 7, tampering with physical evidence, and count 8, possession of heroin, count 9, possession of heroin, count 10, possession of heroin.
How did we get 4 possessions of heroin out of a single incident?
That's exactly what I'm looking up again here. I found probable cause, but let me look again. He had heroin in a pill form, in a pill case, a half a pill of heroin. Then he had a piece of burnt aluminum was located in his shorts pocket, field tested positive for heroin. The vehicle had a pill bottle with 29 pills of amphetamine and a plastic cap containing field test positive heroin residue. While transporting him to the Deerfield District Office, I observed him attempting to swallow an unknown substance. He then began to make a choking noise. So I pulled over to the side of the road. I attempted to get the bag out of his mouth and gave him multiple verbal commands to spit it out. However, he continued his attempt to swallow it. He attempted to destroy evidence later being recovered, identified as 19.4 grams of field-tested positive marijuana. Well, the bottom line is, if it's one incident, I don't know why they're charged, even though it may be located at different locations, why they'd be charging with different counts.
I think that's what they did. So,
Okay.
I'm not gonna ask to perfect, because there's nothing to perfect. If Your Honor just wants to ROR them on those counts, it's probably what makes sense.
Okay, so on 3 of these counts here, where there was an additional $1,000 each count, I'm RORing him that on. So what I'm going to do is, with respect to there's a battery. Okay, on count 1, the battery on an officer, I'll set bond amount of $1,000. On count 2, possession of amphetamine, $1,000. Count 3, possession of heroin, $1,000. Count 4, possession of marijuana, less than 20 grams, $100. Resisting an officer without violence, $100. Resisting an officer with violence, $100, and tampering with evidence, $1,000. So the total bond in this case is $4,200. Count 6. 1, 2, 3, 4, 5. No, count 6 is ROR. No, I'm sorry. This is count 5 would be ROR, and count 6 would be $100. So again, it's 1, 2, 3, 4, 5, $4,200. Okay, thank you.
And you're finding PC on count 1 through 7, but no PC for count 8, 9, and 10?
Yes.
You got it. Okay, Anthony Clare. Anthony is charged with violation of parole. He's being held no bond. He was picked up by the Margate Police Department, the Florida Commission, a parole violation by the Florida Commission on parole. No bond. Thank you. Craig Scottling.
Morning, Judge.
Morning. He's charged in count 1 with DUI, first offense. I find there's probable cause in that offense. Bond is set amount of $500. And on count 2 and 3, he's charged with a violation of probation with respect to a felony. And count 4. Count 2 and count 3 emanate from the same warrant, no bond, and count 4 emanates from a second warrant, no bond.
Okay.
So he has to be held no bond. Thank you.
No bond hold, that's what it means.
Count $500. Enrique de la Pena.
Medical reset, please.
Thank you. Anthony Johnson.
North Broward.
Medical reset?
Medical reset. Thank you. Do I sign this even on medical reset? Okay, and the last case I have is Louis Denkin.
Medical reset.
Medical reset. Okay, I finished exactly at the same time today as I did yesterday. I'm surprised.
Wow, that's pretty good.
Judge, we have one on recall.
We have to arrest Jack
Oh,
Kelly.
Jack Ryan.
Jack Ryan Kelly. He's being held no bond,
Oh, you have, okay.
and I'm gonna ask that Your Honor leave it for the judge that's gonna be assigned to the case to set a bond and have an arthur hearing.
What judge is this assigned to?
Let me double check that. It's gonna be going in front of Judge Michael Robinson.
Roberts.
And Judge, we would join the state in requesting that the court defer to the division judge.
When you say defer, I mean, it's no bond here that's set, but I would urge that this be set in front of Judge Robinson as soon as possible for him to revisit the bond status.
Thank you, Judge.
Okay?
There is an arthur hearing.
Yeah, well, when you say finding probable cause, I don't have to make that determination. There's a no bond Capias that was issued.
Right.
Is it a Capias or a warrant?
No, it's a new case, and at this point, I'm sure the defense is gonna set it down for an arthur hearing, and I think they're agreeing that we don't wanna do a proof evident presumption. Great.
Right, I'm just gonna defer the finding of probable cause until the judge that's assigned this case.
Yes.
Right?
Yes, sir.
Okay.
Thank you, sir.
All right, thank you very much, sir. I appreciate your attention.
Did you sign us up? Okay, down the middle, out the door. Judge, pleasure.
Take care.
Take care. Oh, by the way, Judge, nice tie.
Yeah, Judge Lynch made his point, yes. Thank you. And what division are you assigned to? Oh, you just do bond hearings? That's all you do?
Yeah, normally this is my division Monday through Friday. I'm covering for a colleague this weekend.
So you and Judge Hurley are together every day?
Every day. Well, yeah, every day.
And you as well? Judge Shear, okay. All right, thank you very much.
Nice to meet you, Judge.
Yep, nice meeting you.
So what do we do with these?
Daisy,
Okay.
what's today's date?
17.
Thank you very much, ladies.
Oh, you're
You
welcome,
did a
Anna.
great job.
Stay
You earned your money today.
Thank you.
Okay, so basically I'm gonna take that.
You come into court during the week too, right?
Yes, sir, I work 2 days in the regular court and then 2 days here. It's just 20 hours a
I like that door.
Nice to see you.
Nice seeing you.
You're ready to come back.
Okay.
Oh, this goes, is this to you or is it? But the clerk has to take the original, right?
So these go.
Do I have to sign every one of these pages? Yes. Take care, stay healthy. Let's sign this. I don't know whether she was here. I didn't hear her say a word. Okay.
Not your fault.
Go to the bathroom and let them know.
See her.
With that?
I'm here. Thank you.
Yep.
Bye.
These are done that we have to bring to the 6th floor.
Okay, so let's see, now, as a judge, you can ask these questions, so who's older?
Me.
You are?
Yeah.
Like, what's the age difference?
Almost 3 years.
Really?
Actually, thought you were twins.
Yeah.
I thought so too.
Everyone thinks
but
we're
you're
twins.
The
Everybody
different.
classes are
always
exactly the
I mean,
same.
you guys are different.
Okay, so at what divisions do you work? Do you work in the same division? Don't tell me that happens.
No, not yet.
I'm in Falmouth, she's still in County Clerk.
And what judges are you in front of?
I'm in front of Judge Gottlieb.
I'm in Destry, but I'm moving next week to Judge Singal.
Okay.
It's like deja vu if you get into the courtroom and see you in different courtrooms.
Yep.
Weren't you just here? Yeah, I know.
It happens all the time.
I'm sure.
Alright.
Okay, so,
Yeah, but what, all these, no victim contact stuff, but those aren't from today.
okay, but Erica probably just left in here.
Pat, you were a normal, quiet
These
self.
are
I
my
didn't even know you were
perfections
here.
and medical
Like
resets.
a football referee.
So where do I put medical resets? Because
Don't be
Shane,
scared.
Affecting the game.
okay, because Shane's doing them tomorrow. Okay, so those stay here.
Thank you, ladies.
Yes. Okay.
Are you here again tomorrow?
Oh, no.
Were you here yesterday too, Sam?
No.
Oh, okay.
Did you ladies go to the same university in law school?
We did.
No, not the same undergrad.
That's true.
But we did both go to Big Ten schools.
I went to Indiana, and she went to Wisconsin. So
Undergrad
yeah,
in law school?
law school. We both went to Nova.
And are you from down here or you're up north?
No, we're from here.
So how did you end up going to two different Big Ten schools?
I think I started it.
I mean, she's definitely started the trend, but
There's no connection in your family to those states at all?
Not at
Nope.
all.
Oh.
Just great places.
And where'd you go to law school? Suffolk? New England Law School. Are you from Florida? And you ladies are from Florida too?
Yes.
Okay, no more questions, I promise.
It's okay. Sure, you have me one. Alright, you already did some, right? Wanna shut down? Yeah, shut down.
alright.
Sure, right in this morning was unbelievable.
I missed it. I got in the building before
Is it? Yeah, it's weird out. Okay, those go 6, right?
Are you going upstairs?
Love this.
I.
Okay, I left medical resets here. Cause I think Shane's doing it tomorrow.
That's coming Monday. The mother's coming.
Okay.
And then is this the
What's
one?
infection? There's 2.
2? Okay.
Yeah. Okay.
Hey, Judge, thank you.
Take care, thank you.
Nice to meet you.
Bye, Sam.
Bye, thank you.
Thank you. I don't want you to go unappreciated. Thank you. That Zebedee Wright says, "Oh, you don't trust me?" This guy with 102 counts, it's sad. It's his own daughter.
Is that what it was?
It's his own daughter.
I wasn't too impressed with the gentleman that said was a prior county judge. Is that what he said?
Zebedee Wright? Just got
Is
the,
that Tony?
Oh, yeah. He was here for, years.
Really?
Yeah. Actually, see that building right over there, where the school board is?
Yeah.
That building was named after his, wife. She was killed in a plane crash.
Jeff, we're still broadcasting.
What?
We're still broadcasting.
No, so,
We're still on.
who lights off?
No, but up here it's turned on still.
So what am I supposed to, oh,
Maybe this box right here next to the court reporter.
Volume. I don't see a power
System
button.
on. Okay, is there a button that says sidebar up there?
sidebar? No. Audio controls? System on, okay.